Panelists. Thank you for joining us. We all know that this is also being live streamed on YouTube, so thank you to all those who have joined us this morning. I just would like to tell our participants in particular that there is a survey about the 2-week course that has been emailed to you. It would help us a great deal if you filled out that survey, because we want to make this program as responsive to your thoughts as possible. And please let us know what you found useful, what was not useful, and how we can improve on it for next year. Also, for those who are participating and would like to, on a voluntary basis, come next week, we have some small Q&A sessions organized. In particular, with focus on our students and the students from other law schools that are taking this course. I am here with a very exciting panel that's being moderated by my dear friend and colleague, Renata Amaral. It is our pleasure to be discussing today, as most of you know, the plurilateral approach to trade negotiations. As it has been mentioned several times during the last 2 weeks, multilateral negotiations have been moribund for quite some time. We have had success in small but important areas, such as trade facilitation agreement, and maybe information technology agreement, but overall, it has been extremely difficult. So it is not unusual that countries have moved into regional trading arrangements, and we talked about those, but there's also the plurilateral mechanism that works within the context of the WTO or the multilateral system. And if any of us remember the GATT days, that's how the GATT a la carte went about. It started as sort of plurilateral agreements, and then ultimately it became into a full package. So maybe it's a cycle that we need to go through. I don't know. I'm going to listen to our participants today to learn more about this. We are privileged today to be joined by the Ambassador Alexandre Guido Lopez Parola, currently serving in the permanent mission of Brazil to the WTO and to other economic organizations in Geneva. Previously, Ambassador Parola assumed various positions in the Brazilian government, and he also worked in various positions abroad. The ambassador has extensive experience in trade negotiations and has held relevant positions as head of delegation to the Group of Economic and Trade Issues BRICS meetings in Moscow. The more detailed bio of the ambassador with a link to the website is on Canvas. We are also joined today with Dan Ciuriak. Again, thank you for joining us again this year. A senior fellow at CIGI, where he's exploring the interface between Canada's domestic innovation and international trade and investment, including the development of better metrics to assess the impacts of Canada's trade agreements on innovation outcomes. Based in Ottawa, Dan is the director and principal of Ciuriak Consulting. Dan is also a fellow in resident with C.D. Howe Institute, a distinguished fellow with the Asian Pacific Foundation of Canada, and an associate with PKP Economic Advisors of Munich, Germany. We're also joined by Aluisio Lima-Campos, my colleague here at the law school, also chairman of ABCI Institute. As I mentioned, distinguished trade policy analyst and scholar in residence here at the American University Washington College of Law. Previously, he served as economic advisor to the Embassy of Brazil in Washington, D.C. for over 30 years. He's also a former instructor for the WTO on regional trade policy courses. Last but not least, it's my privilege to introduce Gary Hufbauer, a non-resident senior fellow, was the Institute's Reginald Jones Senior Fellow from 1992 to January 2018. He was previously the Maurice Greenberg Chair and Director of Studies at the Council on Foreign Relations, the Marcus Wallenberg Professor of International Finance Diplomacy at Georgetown University, senior fellow at the Institute for and Deputy Director of the International Law Institute at Georgetown University, Deputy Assistant Secretary for International Trade and Investment Policy at the U.S. Treasury, and the director of the international tax staff at the Treasury. Again, Gary's bio, as well as everybody else's, is found on the website. So I'm going to hand it now over to you, Renata, to have our discussion about plurilateral agreements and whether they are indeed or they are not the wave of the future. Thank you.
Thank you very much, Padidem. I'm delighted to be here in this last day of our program with all of you. Excuse me, I have to admit that this session was inspired by one that Ambassador Parola organized last year for the Geneva Trade Week. We had a great discussion with Gary Hufbauer and the Ambassador. And I do believe this is a very important discussion, and it's not by chance that it is placed in the last day of our program, because it's indeed very, very relevant for the current moment. So I'd like to start asking Aluisio, who is our colleague here at the Washington College of Law, to provide a broad overview of the differences between multilateral and plurilateral agreements and why the discussion is currently very relevant to the WTO system. So please, Aluisio.
Thank you, Renata. Good morning, everyone. I'll try to be brief. Basically, this is to the benefit of those that may be looking at this topic for the first time, so that they can follow, especially the terms that we'll be using that we do every day, but which may sound different or incomprehensible to those of us seeing this topic for the first time. So quickly, multilateral agreements are those subscribed by all WTO members, where all rights and obligations apply to all. Clear examples of that are the agreements on agriculture, basically all the Uruguay round agreements, the subsidies and countervailing measures, safeguards, and so on. Plurilateral agreements, on the other hand, are those subscribed by 3 or more countries, member countries, and not by all WTO members. So that's basically whatever is less than all could be called a plurilateral agreement. And they are basically most of them listed on Annex 4 of the Uruguay round agreements at the WTO. There are 2 types of plurilaterals, basically. Within the confines of WTO, you have open or MFN-like agreements. What these agreements have as specifically to them is that the obligations apply only to the signatories, while the benefits apply to all. So it's called, it's based on MFN principle, and that's why it's mostly known as an MFN type plurilateral. On the other hand, you have the non-MFN type plurilateral or exclusive plurilateral, where rights and obligations apply only to subscribers. In the open or MFN type plurilateral, the information technology agreement is one example. And on the other hand, the exclusive or non-MFN plurilateral, the most classic example, it will be the government procurement agreement, where the government procurement markets are open only to those firms that are located in subscriber countries. So with that said, I think that should give you an idea of what's out there. Of course, plurilaterals can be done outside the WTO, which in my view in particular, it's not a good thing because it's not monitored. So you suffer on transparency, and you suffer also on disciplines that plurilaterals could have if inside the WTO. They have become sort of one big solution to push the WTO ahead. And they have been mentioned by many scholars, including those present here today, as a way out for the WTO. I agree also with that, especially because in plurilaterals, it's easier, they are easier to negotiate because you have less countries involved. And in the case of open plurilaterals, they bring a benefit of having bringing its conclusions, especially the good ones, to all the membership. While in the exclusive ones, they are also a good incentive for countries to join, because if you're not in them, you don't get the benefits. So I will stop there and let the discussion begin, and maybe we can go further deeper into some of the topics of interest. Thank you.
Excellent. Thank you so much, Aluisio, for the overview. I'd like to pass the word now to Ambassador Parola, who is one ambassador that is very vocal on this topic in Geneva. We have had a few chances to talk about this in the past, and I think the mission of Brazil in Geneva is doing is the work that is doing is amazing, and it's not because I'm Brazilian. But Ambassador, I would like to ask for you to provide an overview of the positions of WTO members on this discussion of plurilaterals versus multilaterals, and also explain the reasons related to the evolution of the Brazilian position itself over the past years. So, Ambassador, please.
Well, thank you so very much, Renata. Thank you, Aluisio. It's a pleasure to see you. Good old friends of mine. Thank you, all the panelists. It's a privilege to be here. So let me begin by addressing your point very specifically. I have some notes. I use the notes, but I try to improvise also. I wonder if being very vocal in Geneva is a good thing, but I'll take it as a compliment. And I'll try to be vocal.
It is a compliment.
Okay, it's always a dangerous thing. Let me just make very broad notes about the issue of plurilateral without getting into the technical things first. One very simple principle of life is whatever is not flexible breaks. And plurilaterals are a flexibility in the system. That's the first point. The second question that I would mention is, Aluisio mentioned a way out. I don't think the plurilaterals are a way out. The plurilaterals are part of the DNA of this institution. So they are an alternative way, a second way, but they're not something new to this institution. All you have to do is look at the Annex 4, or then go back in history and look at the Tokyo Round. A third point that I would make is, let's look at the OECD. The OECD is a patchwork of plurilaterals, if we want to look at like that. The OECD members share some major broad views about the world, economic order, how things should be organized, best practices, but they have flexibilities. So the main point that I see now is that we have associated consensus to unanimity. And I would challenge any of you to think of any single example of progress and evolution in social political history that was achieved on the basis of unanimity. Any single one. You pick an example. You may think of something and then you say, oh, there is that. Yeah, okay, but I don't think so. I tried to do this exercise. I couldn't find any single example in which mankind could move on progressively on the basis of unanimity, for the very simple reason that the voice of the conservatives is always present. You always, in any political situation, you have someone who is defending the status quo. And that's what's happening here. The voices that have become more recently very vocal against the plurilateral solutions, they are strong defenders of the status quo for legitimate domestic reasons, which is not my place to comment on. But we need to call things by their names. Defending the multilateral only approach is defending the status quo. That's the conservative position. If we want to make sure that nothing is going to happen in the WTO in the next 2 years, 5 years, 10 years, 20 years, that's the best way to go. And I'll challenge you a very simple exercise for those who have big families. Organize a family dinner with 50 people and try to discuss on the basis of unanimity what you're going to eat. Chances are that you're going to starve. So it's the same thing here. It's exactly the same thing. Those discussions are not too complicated. They're very simple. They're very simple to describe on those terms. A final comment that I will make before moving into my notes is that this discussion is taking place under the auspices also of the Washington College of Law. And it's very becoming that this is so. This is a legal issue. It's not only a legal issue. I wonder if this is mainly a legal issue. This is a political issue, a political economy issue. I mean, the notion of consensus here was created to protect members, but not to forbid members to move on. I mean, the notion of consensus was introduced into the system to make sure that no majorities could be formed occasionally against the interest of one or two. But it was never conceived as a way to make sure that progress will not be achieved. And that's what's happening now. And let me give you a very simple example. E-commerce. E-commerce is a plurilateral initiative. Does anyone think that e-commerce should not be part of the norm setting of the world economy? Does anyone think that e-commerce does not need rules? Of course not. I think that's the future of the economy. Of course, we need norms. So the question is not about plurilaterals or not. The question is, where are those plurilaterals going to take place? And then I couldn't agree more with Aluisio. Should we fail in being able to incorporate plurilaterals into the architecture of the WTO, it will be very bad for the organization because those things will take place. It's not that the world is going to sit and wait for the WTO to solve its own problems. It won't. Those things will take place, but they will take place outside WTO. It's a very simple equation. Either we do those things here, or they will take place somewhere else. And that's the choice that we're facing today. So, I don't know if I need my notes. Maybe it's better that I speak out of the notes. And I'll let myself be guided by Q&A. I can submit to you the notes to be more organized. If you want to share this with students, it might be helpful. But let me talk more freely without the notes. Why does Brazil want plurilaterals? Moving to the second part of your question. Because we're committed to the system. We want a rule-based system. And let me give you an example. The crisis in the appellate body and in the solution mechanism has many reasons. One of the reasons is that associated with the negotiating paralysis, the quasi-judicial branch became too powerful. And they yielded to the temptation, more often than not, to fill the blanks, to overcome ambiguities, as if the ambiguities were not part of the deals. They are. Negotiated ambiguities is a bit of what we do. But the thing is, since for 10 years, we haven't been able to substantially move ahead in negotiations, they felt tempted to do something. So I do understand the critic voices that say there was an overreaching. There's not a weak case. This is a powerful case. And we can find examples of overreaching. But the problem is not the quasi-judicial branch. The problem is the lack of substantial progress in negotiations. So what is the major, this essential rationale of the Brazilian position? It's a very simple one. We want to preserve the system. And we understand that in order for the system to be preserved, we need dramatically to be able to incorporate flexibilities here. The examples of plurilateral negotiations that are taking place now: e-commerce, investment facilitation, gender, MISMIS. Who can be against those things? Who can be against the existence of rules on those things? It's a very difficult argument to sustain. Of course, I can always sit on a very legalist position, on a very conservative position, and say, no, 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 you cannot do that. The problem with this position is that it's going to break the organization. And the problem with this position, for instance, is that imagine that for a reason that I cannot even conceive of, but just for the sake of argument, tomorrow a member decides to unilaterally lower all its protection, tariffs, and everything. I mean, in principle, another member can say, no, I don't accept that. So, I mean, this is a crazy system. It's a crazy argument. And I don't think it's a coincidence that this strong resistance against plurilateralism became more vocal as plurilateralism gained traction. Whilst everyone thought e-commerce was not going anywhere, many members were quiet. As the number of members that joined the e-commerce initiative began to grow and grow in all sectors, in all regions of the world, in all levels of development, then a resistance appeared. Again, it's not my position to comment on the reason for that. I'm just detecting a phenomenon. That's how it happened. That's how it took place. Let me just make a final comment. Associated with plurilaterals is the idea of sectorals. I mean, the plurilateral initiatives are not supposed to replicate the whole structure. They are supposed to consider a sector, however you design the sector, and move on and move ahead in this. I mean, without prejudice of the balance of rights and obligations of all the members. I'm not going to get into the discussion now for open MFN, full MFN, or qualified MFN. MFN is a wonderful principle. It's a central principle of the system, but it should not be associated with the free riders. I mean, we need to be committed to the system. Otherwise, the system will not work. It's like me being a member of a club. I mean, if I only want to go to the club, but I never pay the fees, and I never do anything for the benefit of the club, maybe I'm in the wrong club. Those are questions that we need to address very face on. We shouldn't be afraid of having those discussions. The most important message that I'd like to convey is a very simple one, is that the voices that are raised today against plurilateralism are voices of the status quo. They do not want to change the system because they are very, very comfortable in making sure that nothing happens, because this fits domestic choices. Again, everything is legitimate, everything is valid. There are reasons to do that. Again, it's not my point, it's not my position to comment on those reasons, but it's important to understand what's going on. But sorry, I didn't read my notes, so maybe I spoke too much and I was vocal again. But thank you very much again.
Oh, this was fascinating. Thank you, Ambassador. I really like to listen to your arguments. And I just wanted to remind people that are listening to us, because Aluisio and the Ambassador mentioned a lot the MFN principle, and it's Article 1 of the GATT, Most Favored Nation. We are going to make a deep dive on this with Gary, probably within the following questions, but I just would like to remind you that it's Article 1 of the GATT 1994. Dan, I would like to turn to you. The Ambassador mentioned a few times the e-commerce negotiations, and I know you are following this very closely. And those negotiations, they happen on a plurilateral basis. So could you explain what is the focus of those negotiations, the opportunities and challenges related to it? And also, In the context of negotiations, could you talk a little bit about the Digital Economic Partnership Agreement, DEPA, between Singapore, Chile, and New Zealand, which seems to be a first of its kind agreement that establishes new approaches and collaborations in digital trade issues? Dan, please.
Sure, thanks, Renata. Yeah, as the ambassador said, the WTO e-commerce negotiations are really important. The digital transformation is proceeding at pace. Much more commerce is moving into the digital space, either digital trade or digitally enabled trade. And so the rules for this are important. The WTO is really lagging badly here. The adaptation of trade rules to take advantage of the digital transformation that's been underway for a long time. The UNCITRAL model law on e-commerce dates back to 1996. So 1 year after the WTO came into existence, and we still do not have a WTO e-commerce regime. Now, in terms of the specifics of what's going on in the WTO, most of it is well-trodden turf. We have fully fleshed out e-commerce trade facilitation regimes already established, for example, in the Trans-Pacific Partnership and the recent US-Mexico-Canada agreement, the USMCA. However, establishing a WTO regime, as the ambassador said, would be very important in terms of enhancing its legitimacy and, of course, the geographical coverage, since it will be open to WTO members that are not parties to such regional trade agreements. In terms of the issues that are being addressed, is that the turf is really well trodden. We cover things like electronic signatures, authentication, paperless trading, consumer protection, including the protection of personally identifiable information. Open government data is addressed, unsolicited commercial messages or spam. And of course, perhaps two of the most important issues recently, cross-border data flows and localization of computer facilities. So you will find language, well-developed, I would say boilerplate language now in the TPP and the USMCA on many of these issues and other regional trade agreements. So we won't see much innovation at the WTO in those areas. But a major important issue for the WTO regime will be policy space. And here I suspect that's where most of the negotiation is with regard to carving out that policy space. So different WTO members will have different interests and will place different values on what is to be freely allowed, what is to be controlled, and what is to be prohibited. This is because with datafication, our societies are moving online. The e-commerce platforms are both an agora as well as a marketplace. So they affect our society very, very deeply. And so differences in societal choices will be important here. And we'll see, I think, significant differences in areas such as privacy, for example. We have privacy regimes in the US, which are very different from those in the European Union. And China has just adopted new data privacy and data security laws, which are looking a lot more like the GDPR. And the US at the state level is moving in that same direction. So we're actually having, at the national level, regimes being developed. And the question will be how this will be all made interoperable at the WTO level. And there are also issues such as, for example, the use of facial recognition. This is actually permitted in the US, but not in all states. Some cities like San Francisco moved to forbid it. The question is, how can this be used? What is lawful access to mean in terms of access by governments to information held by private parties? So these are very important issues for national security. Now, the GATS framework, Articles 14 and 14 bis, apply here on a technological neutral basis. So the real action is actually at the national level in terms of what the specifics will be for the digital economy. A major issue for the WTO is the moratorium on the imposition of tariffs on electronic transmission. This has been important for developing countries, which are seeing an erosion of tariff revenues as products that were formerly dutiable, for example, musical CDs, now become electronic transmissions, and they are seeing an erosion of their tariff revenues and need to make tax adjustments as a result. So they've been, this issue has been a live one at the WTO, and it's rolled up with the issue of a digital services tax. That's not being addressed directly in the WTO, but it is being addressed through the OECD, and where there's been a recent agreement on a 15% minimum tax on multinationals, which includes multinationals doing business in a country where they do not have a physical taxable presence nor at present. So this is one of the key changes in the digital environment, is that a company can do business in a country, and very significant business, and earn a lot of profit in a country without actually having a taxable presence there. So we'll see whether this holds or not. Now, perhaps just turning to the deeper briefly, the deeper covers all of that stuff as well, but it actually goes a bit further, and it gets into things, for example, like the interoperability between parties' digital identities and the protection of digital identities. So there's a bit more forward-looking language there. It gets into fintech. And we will see issues of the use of electronic payments on a cross-border basis, which will become very important. E-currencies are only now being rolled out on a trial basis. That's still not yet touched on even in the DEPA. Another area which is broached by the DEPA is that of artificial intelligence. And now if we think about the role of artificial intelligence in the innovation system, the issue, for example, recently there's been litigation over whether artificial intelligence can be assigned a patent as an inventor. There are lots of issues there to be addressed, which are the WTO regime for intellectual property was formed back in 1995 and little changed since then. The world is moving very, very rapidly here. So there will be important developments to come. The DEPA itself just touches on these things, so it doesn't actually have a fleshed out regime, but at least it's signaling where the regulation of digital commerce will have to go. And finally, another one that I think is very important is that is competition. Competition policy was excluded from the WTO agreement in 1995 and kicked over into the Singapore issues as one of the things to be decided in the future. And now in the context of the platform economies, competition policy is actually de facto market access. The competition authorities are now critical players in what can be done in a country. And here again, we have national regulatory sandboxes at play. The EU, of course, has been out front on the issues of antitrust actions by or anti-competitive actions by the platform firms. The U.S. has now started to look at that very carefully with the appointment of Lina Khan to the Federal Trade Commission. And even China, perhaps for different reasons, has also been tackling the power and anti-competitive practices of the big platforms. So what we're seeing is that, again, the DEPA touches on this without developing. So what we have is an established regime, primarily at the RTA level. The WTO is behind the curve, but trying to catch up and must catch up for its own credibility for the future, given the importance of e-commerce in the world. And the real action, however, is taking place at the national level, and I would call this in the regulatory sandbox sphere, where all the difficult issues relating to datafication and how the digital economy actually works are being addressed. And on the positive side, what I'm seeing at least is a lot of convergence as different countries coming from very, very different societal regimes grappling with the same kinds of issues. Every society has got its issues of privacy and what's in the public sphere. They may draw the line in a different space, but in point of fact, they have to deal with many of the same issues, and they're coming to similar solutions. So I think it's a positive sort of outlook for a future regime, but we have a long way to go.
Excellent, excellent. I think we could make a separate session only on this. Thank you so much then. Gary, I think you were the first person that started advocating for plurilaterals in a global basis. You have a bunch of articles written about this. So I would like to discuss a little bit more about the MFN principle within plurilaterals or without. So the agreements that we are discussing, the plurilateral agreements, they can be conditioned or not to the most favored nation principle. So this is really not a simple definition. It might seem simple, but it's really not simple. Aluisio started to comment on that a little bit. I'll ask him also to comment again after your remarks. But could you, Gary, please explain what are the differences between both approaches, and also talk a little bit about India's and South Africa's objection on any plurilateral outside the scope of Annex 4? Gary.
Thanks very much, Renata. Those are good questions. Let me start with a little preamble on this, some of which echoes what the ambassador has so eloquently put forward. You had a great session on regional trade agreements, and I was able to listen to the YouTube version yesterday. And one of the speakers, David Gantz, whom I know quite well, basically said the WTO is dead. A pretty strong statement he made in that, and that the future is the regional agreements. And the reason he said the WTO is dead is exactly what the ambassador pointed to, the so-called consensus principle, which really means unanimity. Any one of the 164 members can object, and you can't have a consensus per the definitions adopted by the WTO. And as the ambassador said, that's kind of a formula for not making any progress. And that's why David Gantz said that the WTO as a negotiating forum had come to the end of the road. Well, the plurilateral agreements, which have always been part of the WTO, again, as the ambassador said, when you go back to the original GATT, there are a lot of kind of plurilateral approaches within the original GATT for particular members who were in pre-World War II arrangements with other countries and so forth. So it's always been there, and it needs to be given more emphasis going forward. Now, let me speak to a weakness that the regional trade agreements have that the WTO at one point did not have. The regional trade agreements don't have any effective dispute settlement. This was also said in your meeting on regional trade agreements. None of them, not the old NAFTA, not the USMCA, they're not very effective. And many have really no effective dispute settlement. They have architecture which hasn't been used. We will see in the future. Now, at one time, the WTO had quite an effective, and as the ambassador indicated, maybe too effective a dispute settlement mechanism in the sense that it filled in blanks which the negotiators had not agreed to. And that's one of the issues that the U.S. focused on in terms of not appointing appellate body members. So that's an aspect of the WTO which hopefully will be revived with reforms. That is the dispute settlement, and that gives it a plus versus the regional trade agreement. But it has to deal with this this consensus issue. Now let me turn very briefly to the objections of India and South Africa, which focus on Annex 4 of the Marrakesh Agreement. Annex 4 named 4 plurilateral agreements at the time, and civil aviation and government procurement were probably the most important. They're still functioning, sort of. There was another on bovine meat, and there's a fourth one which I forget. But in any event, those other two have faded away and are no longer active. Now, the Marrakesh Agreement also said that it took consensus to add to Annex 4. And India and South Africa take the position, which I dispute, but anyway, they take the position that the only plurilateral agreements which can exist within the WTO framework have to be adopted by consensus under Annex 4. Now that ignores, as the ambassador said, the whole history of the WTO and the GATT before it, which had nested within it many aspects of plurilateral agreements. And from a legal standpoint, the real weakness of the India and South Africa position is that it takes 3/4 of the members to adopt an interpretation. That is the interpretation which they are urging as to any future plurilateral agreements, which now go under the name of joint statement initiatives. And I don't see how India and South Africa can get 3/4 of the members to agree on this. Again, as the ambassador said, the status quo, no agreements going forward, which are less than all the members of the WTO. So I think that's their big legal weakness. Now, finally, after that long prelude, coming to your critical question, Renata, on the exclusive or open agreements, to use the language which Aluisio used at the beginning, or another way of putting it is a most favored nation or conditional most favored nation. Conditional most favored nation meaning that you don't get the rights unless you take on the obligations. Most favored nation with no adjective is you get the rights even though you don't take on the obligations. Now, that's a really critical difference between regional agreements and the WTO. In regional agreements, you don't get the rights unless you join the region. And that's a big attraction of regional agreements, that the rights are limited to those members of the agreement. Zero tariffs and many others, intellectual property and on and on. So in my view, going forward, the plurilateral agreements, to have any meat, will probably have to be, in most cases, of a conditional MFN nature, or as Aluisio said, exclusive. That is, you don't get the rights unless you take on the obligations. However, any WTO member has the ability to join in the future. In other words, it's not a closed club the way regional agreements are closed clubs. You're either the existing members let you in or they don't. But in the WTO, it would be an open club in terms of being able to join as a formulation going forward. So let me just pick up a little bit on what Dan said about e-commerce. I mean, there are many contentious issues in e-commerce, and let me just take one of them: localization of computer equipment and the people, more importantly than the actual servers, the people who do the analysis of the data. If an e-commerce agrees that we won't have localization requirements, I don't see how the members of that agreement will let some country which, doesn't agree to these no localization standards be a member and enjoy access on the same basis to all the other members, but it can proceed with its own localization, really meaning its own protectionist elements in an e-commerce agreement. I just don't see it going forward. And in every other important area, climate change, investment, so forth, I think you run into exactly the same problems. So that's my strong argument for permitting what would be called exclusive or conditional MFN plurilateral agreements going forward. And let me stop there. Thank you.
Gary, there is a question that just occurred to me, if I may address this to you. What in the ideal world, the way you see the WTO moving forward, the multilateral agreements that already exist, that are already in place, they would remain as they are, and decisions would remain being made by a consensus. And then moving forward, we'll talk only about plurilaterals. How do you see that? How would be the organization within the members moving forward?
Well, my view would be that in the pioneering areas, there'd be subgroups of members who would agree, but not all the members. And then going forward, as we did, which is again recurring to the ambassador, the history of the Tokyo round was a series of plurilateral agreements, which then were unified in multilateral obligations and rights when the WTO was created in 1995. Well, that would be the path I would see going forward. There'd be pioneering subjects, and eventually there'd be more and more members joining, and eventually it'd be the whole group. But let me come to a very important point on this small groups on individual issues. As we know in the world today, many regional agreements have a very strong political dimension to them. I mean, they're like-minded countries, basically allies. So there are a lot of countries which are not like-minded, and we can take a number of dyads or pairs that are not. Pakistan, India. I used to live in that part of the world. Ukraine, Russia, and of course the big one, China, the US. These countries don't agree. They're politically opposed. However, there could be issues on which they could agree within a plurilateral, the technical issues which don't get into the heavy-duty geopolitical problems. And that could be the subject matter, and a very useful subject matter within the WTO.
Excellent. Thank you so much. Aluisio, would like to invite you to jump in this discussion and provide your overviews, because I know you and Gary talk about this. So please, your comments.
Yes, I cannot disagree with anything that Gary said. In fact, I thought we had a disagreement in the past, and I was ready to discuss on that. But based on what you said today, I said, hey, welcome to the club. I agree with everything you said. And I think that the exclusive or the conditional MFN plurilateral is probably the best way to go, especially being such a big incentive for others to join. But there is and I like to focus my comments now on this. There's a small problem within the legal framework in the WTO with regards to that. You have on a requirement, for example, you could try to get a waiver of an MFN clause in a plurilateral agreement, and it will take 3/4 vote to get that approved. Now, let's say you get it. Then you have an Article 10 another problem, because it would require consensus in order to include that plurilateral in the Annex 4. That for me is an incentive not to stay in the WTO, but to go outside the WTO. And I think that if we look forward and looking at reform, especially dispute settlement reform, I think it's very important to look at that particular situation and see what can be done in terms of bringing flexibility to Article 10 in order to allow, if we have a vote or a voting procedure established, that voting procedure can stick and not be prejudiced by a requirement of consensus in order to keep it inside the WTO, which doesn't make sense to me. But well, many other things don't make sense to me. But you know, that one in particular is, in my view, very important, and I would love to hear what my colleague panelists think about that. Thank you.
Thank you, Aluisio. That's excellent. Since the beginning of this session, we have been touching on the discussion of what are the benefits of negotiating in or outside the WTO. As Gary mentioned, we had a great session last week on regional approaches to trade with Gary Horlick, David Gans, and Geneva Remy. So, Ambassador, I would like to address this one to you. Taking into account all this discussion on plurilateral or multilateral agreements, I would like to hear from you what are the pros and cons for WTO members in holding negotiations in and outside the organization, and why is it, or it's not, still worth it to negotiate within the WTO rules, even if we are talking about plurilateral agreements? Ambassador, please. I think you're muted.
Can you hear me now?
Yes.
All right.
Yes.
Thank you very much. Let me just make a brief reference to the WTO dying. WTO will be just like the old soldiers. They never die. They fade away. We won't die. We will become irrelevant. That's the real threat. Another thing, trying to answer your question directly, I don't think there's a real opposition between WTO and regional agreements, WTO and bilateral agreements outside WTO. Those things, they should complement each other. They should converge. At the end of the day, what we need is a multilateral trading system. The WTO is one example of a multilateral trading system. If it fails historically, then we need to think of something else. But before we think of something else, which is going to be a very challenging exercise in economic diplomacy or in even geopolitical diplomacy, we may need to face this challenge. I don't exclude this possibility. I don't think this organization will survive another 20 years of paralysis. It won't make sense. But then again, it won't disappear. The building will be here. The Secretariat is a very high level. They will be here. The history will be here. But the interest won't be here. The vitality will be gone. And then we need to rebuild somewhere else. I have very little doubt about this. So this is the moment to make sure that this organization matters. Before I answer your question, how do I see the reform of the WTO? I would like to think of the motto of the G20 in Italy, which is a very, very clever motto, which is people, planet, and prosperity. Those are the three things that should guide us WTO in our reform. We need to go back to principles. We need to remember what brought us here together. And what brought us here together was something very simple, was the shared conviction that trade generates prosperity and that trade is good. If you believe that trade does not generate prosperity, and if your behavior in this organization is to make sure that trade does not go ahead because you need to protect yourself from trade, there's a problem. It's like if I joined a football club and try to play bridge. I mean, it doesn't make sense. I mean, it's a football club. Join another club. Go play bridge. Nobody forces you to join this. But this is a central tenet of what brings us together here. So we need to go back to basics. Say, well, trade is important. Trade generates prosperity. How do we make sure that this can happen? This is the first thing. Two other things are essential. Trade is an essential tool in the toolbox of poverty fighting. Because it generates prosperity, it generates better jobs, it generates new jobs, it integrates women in the workforce. It is a force for the good. It is a good thing. I do not need to protect my economy from trade. I need to protect my economy from the negative effects of trade, and in time make sure that I can better integrate. Without this attitude, there's no future for this organization. And another thing is the planet dimension. Sustainability is not a fashion. It has come to stay. It is going to be one of the central requirements of any negotiation we endeavor. And Brazil is ready to engage in that. We can bring very important assets to the table. We want to be part of any negotiation, any discussion in this area. So we need to, the reform of the WTO has to be a greener reform. It has to be a poverty alleviation organization, and it has to be one that knows and understands that trade generates prosperity. If we fail in those things, and then the plurilaterals are part of this package, how do we do this? We can, e-commerce is a good example. We can have e-commerce outside the WTO. It won't have the benefits of the system. By definition, it's not going to be MFN, because regional is not an MFN. So let's benefit from the system. Let's benefit from our history. Let's benefit from initiatives that have been in place for at least since 1947, because this is the history of the organization. Let's give you an example and almost two provocations. The same voices that now are against the plurilaterals and claim that we should be truly multilateral are voices that back in the day, because I'm an old timer in this organization, played a very important part in obstructing the Doha round. And now they want the Doha mandate. What do you mean you want the Doha mandate? You didn't want the Doha mandate in 2008, and now you want the Doha mandate. I had a very interesting discussion with a high authority of one of those members. He said, no, we need to go back to the Doha mandate. I said, well, it's perfect. I mean, if you agree with me, the next session, I will defend that we sign tomorrow, Rev 3 and Rev 4, in and egg, and we close the deal. Are you ready to do that? Said, oh, no way. I said, okay, so be serious then. No, let's look ahead. Let's not use the past as a pretext for nothing happening. I mean, and then again, I'm not going to judge the merit of those positions. Obstruction has a logic. I mean, in the almost 20 years in which we are paralyzed here, the world economy changed a lot. Let's look at domestic support in agriculture. The landscape 20 years ago was completely different from the landscape today. Just to do the exercise to look at the heavy subsidizers, who they were 20 years ago, who they are now, and then you understand the reason for obstruction. The thing is, those things need to be said. They need to be brought to the debate. I think the fair thing to say is, my position is informed by the conviction that I benefit from nothing happening. Then it's a clear discussion. But then you cannot use the legal pretext to paralyze everything. We need to find a solution for that. I understand how difficult it is legally. I do understand. Because even the notion of authoritative interpretation is subjected to consensus. So it's very difficult. We need to find a solution. But I hope that in time we will find a solution. But maybe it's just part of being optimistic. But thank you, Renata.
I think we all need to be optimistic, right? We are all WTO cheerleaders. So then I would like to turn to you, because you did make a very good point during our prep call on Monday. It was a point that you were referring to negotiation among allies and the geopolitical divide into multilateralism. So could you please share your comments with the audience, because I think they were really fascinating. So then.
Sure, thanks, Renata. Actually, this builds very much on Gary's discussion about sort of the like-minded parties which get together. I think it's helpful to think back to the origins of the GATT. When the International Trade Organization did not go ahead, it was to be the third stool with the IMF and World Bank of this new international post-war order. The GATT came into being as a 23-member group, which is essentially an alliance group. With the, Francis Fukuyama's end of history, with the fall of the Berlin Wall, that structure ceased to be really meaningful. And so Russia and then China acceded to the WTO, and you had a truly world multilateral system in place. And at that time, you didn't have this glaring a geopolitical divide. It was a unipolar world. But the origins of the WTO, actually, in the GATT, came from an alliance structure. With the changes in the tectonic sort of plate shifting with the rise of China, and in fact the emergence of Russia as much more of a rogue state under Vladimir Putin, the world looks very, very different today than it did in 2001 or 2 at that time. And so now we have the challenge of how on earth do we live with and work with these countries, which, as Gary said, are not like-minded with us in many ways. So one way to actually approach this is to think about the commonalities. For example, there's a very important nexus between data protection, privacy, and lawful access regimes that provide government access to personal data held by the private sector. And we have an OECD working group on that. It's called Government Access to Personal Data Held by the Private Sector. Very original. Now, China has got a law that explicitly requires private actors to turn over their data to the authorities upon request. It's not clear that there's how much daylight there is between those two regimes. The issue is not so much the difference in government access to private data in a lawful sense as the question of whether or not that data can flow across a security divide. And this reflects the difference in the modern data-driven, digitally transformed economy and the earlier version of the economy, which is basically analog. Data can be used to manipulate electorates, and we've seen that in the Russian interference in the U.S. election. We saw, actually, interestingly enough, the actions of private actors using artificial intelligence and other techniques interfering in Brexit. And engage, if you haven't followed Carol Cadwalader's stories on that, you've missed something. So the question comes in, how are our governments going to secure their societies in this data-driven world? And we don't have the answers to that. So one of the solutions may be that you cannot actually have actors from one country playing across that security divide. For example, Huawei providing telecommunications equipment. You might say, well, it's just hardware, but we know that in the modern world, software is eating the hardware. It's much more software, and data becomes an important part of that infrastructure. So the question is, can you have that participation? I would observe in Canada that the backbone infrastructure of our economy has always included crown corporations. We had Air Canada and Canadian National Railways for transportation, Petro-Canada for energy. We have Hydro-Quebec and Ontario Hydro, et cetera. And in the telecommunications was highly regulated. In finance, we had a 10% limitation on ownership of our banks to make sure they could not be taken over and have our finances run from, whether from New York or London or Tokyo or elsewhere. So we've had strong, tight control over this backbone infrastructure. And now in the modern world, with the digital transformation, this infrastructure becomes akin to an interactive central nervous system for the economy with no definable borders. So the question again is how do we actually frame a regime that allows international trade and commerce in this space and yet safeguard our national security and our national sovereignty? So I don't think there are easy answers here, and the kind of sort of regime that Gary proposes of conditional MFN may be possible in areas where, for example, you say certain kinds of data will be allowed to flow across borders and certain will not. For example, China has got a new interest in cross-border data flows because with the digital Silk Road, it now has got offensive interest in that area in terms of having its companies play globally. And it has entered into a free flow of data regime under RCEP with conditions. So maybe those kinds of conditions are what will permit a certain level or certain type of data to flow with control and others not. That's one way forward. And a second way obviously is possibly complete decoupling in certain specific areas that are simply considered to be too sensitive or not possible to control. But I think this is, the GATT started out as an alliance system, and it's gone through a truly globalized, hyper-globalized framework. And now it's perhaps moving back under the WTO into a more compartmentalized world. But still, it is a big house. It provides room for all these players, and it provides dispute settlement. And China and the WTO and the US are taking each other to the WTO. I think that's a very healthy way to go forward, as opposed to, for example, other means. So I'll leave it at that.
Excellent. Thank you so much. Gary, I would like to, Aluisio, would you like to comment?
A very short one. It just, as Dan was speaking, just came to me, which is a very important point. There are certain subjects or topics that plurilaterals won't do. And one example of that would be subsidies, for example. You can only have an agreement there at the multilateral level because, it's important, it's impossible to divide subsidies from country to country. Subsidies are there, and it's embedded in the exports, and there's nothing you can do to separate that in your exports to one country or another. So there's still room for there are subjects that only multilateral agreements can work, but plurilaterals are there, and certainly the topic that Dan was discussing seems to be very difficult to be incorporated into a plurilateral. It looks very much like the subsidies area, in which you cannot separate things from country to country, in which case maybe only a multilateral will resolve. But in any case, there's still a lot of questions there, and it's a new world on that topic. So I'll stop there.
Excellent. Thank you, Aluisio. So Gary, I would like to turn the final question I have to you before we go to the questions. I think we should at least have 5 minutes to address the questions from the audience. But I think this question for you, actually, it's a great introduction for our last panel that is following yours. So approximately 2 months ago, you published a blog post with the Peterson Institute entitled "Focused Trade Agreements Can Sustain the WTO in Time of Economic Nationalism." And one of your conclusions is that plurilateral agreements among subsets of members introduce essential flexibility for the WTO to continue its vital role as a negotiating forum. So could you comment a little bit briefly about your conclusions in this paper? The paper is available to the participants of this program already in the Canvas platform. Gary.
Sure. Thank you, Renata, and thanks for hosting this whole program. Let me start by just echoing some of the points made by my colleagues on this panel. First, the consensus rule is a way of stopping progress. And so we have to find ways of working around the consensus rule, and clever lawyers like Aluisio and others can do that within the WTO framework. Secondly, the regional agreements, which are very strong, and there are more than 300 of them, while they seem to be pretty all-encompassing, are not, because there are many smaller countries, especially middle-sized and smaller countries, which don't belong to a regional agreement, or at least don't belong to a strong regional agreement. And the rules that they have will be WTO rules, including, of course, plurilateral agreements to which they subscribe. And third, as Dan has emphasized, we basically have the strongest regional agreements are essentially alliance agreements, the EU, USMCA, and others. And that leaves a lot of space between countries which are not natural allies, but which have a great deal of commerce between them, which, is crying out for rules. E-commerce, climate, any rules we devise on climate, and so forth, those apply to countries which are not allies, or should apply to countries which are not allies, as well as countries that are allies. So here's where the plurilaterals can play a role. Now, looking at the big picture, the challenge to the WTO is to be relevant in a world where we have another very strong organization which has a big share of the world economy already, and that's the Comprehensive and Progressive Trans-Pacific Partnership, what was developed after the US left the Trans-Pacific Partnership. The other countries formed the CPTPP. And the UK has applied to the CPTPP. Of course, you've got the Pacific in the title, but we can modify the title. They could modify the title if the other countries want to have the UK within. And not too far from now, China has indicated it has an interest. And you can find technical reasons why maybe China doesn't meet all the current standards, but if China has a serious interest, they will change. Some of the technical standards might be delayed in terms of their application. And the Chinese interest then in turn whets the US interest to rejoin. And there are many congressmen who are now in the Ways and Means Committee, Senate Finance, who are urging the US to reconsider that very bad decision that President Trump made to drop from the TPP. Well, now if China and the US come in, you've got, 2/3 of the world economy in this CPTPP, which might be renamed. And that's a big challenge to the WTO. As an institutional challenge, that's the big boy on the block, which might take over. It doesn't have an effective dispute settlement that we know about yet operating, but it might get one. But my concern about that brave new world, if it emerges, is that it leaves out an awful lot of countries in Africa, in Latin America, Central Asia, and so forth. And so there's a real need for, just coming back to your question, Renata, for the WTO to step up its game under its new Director General, Ngozi and to move forward very much along the lines of what the ambassador said right at the outset and become a place for meaningful negotiation on all the 21st century issues. Thank you.
Excellent. Thank you, Gary. We have 3 questions. I'm gonna make them all at once, and I would like to give you 3 to 4 minutes to answer because we have another panel in 12 minutes, more or less. So, but I would like to address because they are very good questions. The first basket of questions are from Jonathan dos Santos. To what extent members of RTAs and plurilateral talks agreements could effectively ensure that rights created in these arrangements will be limited only to their participants, especially considering the emphasis on non-tariff matters? The second question by Jonathan as well. Has the WTO been effective in reviewing RTAs, FTAs, so as to ensure they are in conformity with the multilateral rules, and in doing so, those initiatives create rather than divert trade? What should be the approach going forward, considering plurilateral arrangements and their potential impacts on the multilateral system? Those are from Jonathan. And the final question that maybe could go to the ambassador. Does the WTO suffer from its success? It's from Maria Fernanda Pareski. So who'd like to answer or try to answer the first questions? Any candidate? Them, please.
Sure, I'll take a stab. First of all, we actually model trade agreements. And so we try and take into account whether or not the implementation of a measure in a regional trade agreement has multilateral or restricted effect. And typically in rules areas, for example, if an RTA requires that there be a single window for customs, you won't build a single window for just a few countries. You'll probably have that single window for everyone. So these tend to have multilateral effects. And those are actually the rules part of RTAs tend to be multilateral in effect. Now, in specific areas, you may not have access to dispute settlement and enforcement, so the non-parties may have weaker effective protections under the trade agreement. But on the issue of trade diversion and trade creation, the minute that you create preferences, you have automatically trade diversion. So the only question with the trade agreement is just how much of the impact is biodiversion versus trade creation. There have been exercises in analyzing these. And so, for example, the North American trade agreement, the NAFTA, was generally trade creating on balance, whereas the Mercosur was deemed to be actually more trade diverting than trade creating. That's an empirical assessment. And the USMCA is more trade diverting than NAFTA. So that's the way to look at that issue.
Excellent. Thank you so much, Dan. And the final question, does the WTO suffer from its success? Maybe the ambassador, Gary, Aluisio?
I'll suggest the ambassador.
Thank you very much.
I thought so.
Yeah. It's wonderful to have friends. Thank you, and thanks for your question. It has been successful, but it's like a bicycle. It needs to keep moving. Otherwise, it will fall. Success breeds success, and paralysis breeds paralysis. I think the WTO is victim of many things. Success is one of those things. The other one is the dramatic transformation in the broad geopolitical picture. The WTO does not exist in a vacuum. It represents a certain distribution of power and wealth in the world. Once this distribution of power and wealth changes, it's natural that tensions will arrive here. So the main question from this broad perspective is how flexible this institution is to adapt to new times. And then I make a comment here also as a provocation. We all know the Gato Pardo, the book, in which the senator says, well, some things need to change so that nothing changes. The interesting thing here is that we have two general negotiating attitudes. One of them is based on the idea that everything has to change so that nothing changes. The other attitude is we need that nothing changes so that everything changes. So that's how those two big players approach the status quo. And this is very interesting. And there was just a comment about the interests of the US and China. I don't worry about the US and China. I think that both of them are and will be very committed to have a system based on rules. I mean, it's part of power to have a system of rules. It's good. I mean, rules are a public good. So it's important, but we need to be flexible. We need to adapt to new times. Plurilaterals are part of this flexibility. Without that, we are going to suffer existentially, for lack of a better word. But I don't know if that answers the question, but that's how I see it. Thank you.
It does. And I'm very grateful to the four of you for kicking off our Friday, our final day of the summer program with such a fascinating discussion. Thank you very much.
I just want to also thank everyone. It's wonderful to have this opportunity to have you all participate. This discussion is not ending. As we can see, there's much to be done, and we look forward to inviting you again, hopefully even in person, to our building in Washington. This program can be accessed on the WCL's YouTube channel at any time if you want to forward it also to others. Thank you so much.
Thank you. Have a good day.
We are going
you.
to, thank you. We're going to take about until 10:30 and then we will resume with our next session. Thank you.
Thank you so much.